right, the time is 3 o'clock on Tuesday, July 15th, 2025. I'm calling to order the Board of Equalization. Today we have with us Commissioners Kelly, Burmeister, Warren, Mixon, and Klug, as well as our County Administrator Bonnie Moore, Kendra Kaler from the Clerk and Register of Deeds Office. We have Jason Carter and Jeff Mikesell from the Treasurer's Office, Dan Pittman, our County Assessor. And with that, we are good. If you could, please silence your cell phones and stand for the Pledge of Allegiance. I pledge
allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
A copy of the Nebraska Open Meetings Act is located in the north wall of the county boardroom. With that, we'll move to agenda item 4, which is public comments. Is there anybody in the audience that wishes to address the board before we move on to the rest of board equalization agenda? And seeing none, we'll move on to item 5, is the consent equalization agenda.
Motion to approve. Second.
Motion by Warren, second by Mixon. Any discussion? Please vote.
Don, you're offline. Are you an A?
Yeah.
Okay.
I'm a yes.
A's 5, nays none. Motion carried.
All right, moving to the regular equalization agenda. 6.1 is neighborhood community pantry permissive exemption request discussion. Andrea Gosnell Parker, Civil Division Lead.
Good afternoon, Commissioners. On July 24th, 2025, June, Neighborgood addressed the board during open public comment regarding 2024 taxes of their property. For purposes of background, Neighborgood Pantry purchased their property on December 30th, or rather they closed on that date, 2024, and an application for exemption for the property was received by the assessor that same day. The form used was for a 2025 exemption, however, the date was modified by the applicant to reflect 2024. No separate application or statement of confirmation for 2025 was filed. Per the assessor policy and direction of the Nebraska Department of Revenue, given the filing date and the fact that all application deadlines for 2024 had passed, the application was processed and presented to the board as an application for a 2025 exemption. This prevented a late filing from occurring for 2025. On the date the property was purchased, there were no statutory mechanisms available to exempt the property from taxes for the 2024 tax year. So in looking at the discussion, the first thing is taxes in Nebraska are paid in arrears. This is standard across all counties in Nebraska, and it's a statutory function. Basically, properties are valued as of January 1st of a given year. There's then a period of time in which those valuations can be corrected, adjusted, protested, and before we arrive at the final date where valuations are essentially set. October 20th is the date in which the tax levy is set. This is basically the rate that will be applied to the valuations that were found for January 1st. Tax is then attached to the property on December 31st of that year. So given the methodology that's outlined in statute, the county just assesses its taxes in arrears, the whole state does. It's not an individual county decision. The only way that we could change this is through legislative action. Next, looking at the permissive exemption process, Neighborgood, as the type of entity that it is, would qualify for a permissive tax exemption as they were approved for 2025. Now, the statutory deadlines for applying for permissive exemptions are very set, and unfortunately, there's really not any wiggle room in them at all. So for properties that are owned prior to the year in which the exemption is requested, the filing deadline is December 31st. There is the ability to ask for a waiver of that deadline and apply until June 30th with a penalty, but that is only if the property has been previously owned. If a property is obtained or converted to exempt use between January 1st and July 1st, the entity does have the option of applying until July 1st. If somehow the property is obtained from an organization that was also exempt and it's purchased prior to the levy date, then entities can apply until November 15th. In this case, the application was submitted on December 30th, which is beyond all of those deadlines. Really, it seems that the overarching intent of the statutes is that the property be an exempt use for at least half the year in order to qualify for a tax exemption. Usually, when we have cases where a property is purchased so late in the year, property taxes will be addressed in the purchase agreement. I did take a look at the Omaha Area Board of Realtors Uniform Purchase Agreement. For some reason, it does differentiate Sarpy and Douglas from the rest of the counties in Nebraska. The rest of the counties in Nebraska will estimate what the taxes to be paid will be, and then allocate those proportionately to the buyer and seller, depending on the time of year that they purchase the property. The Uniform Purchase Agreement, though, does state that for Douglas and Sarpy, they consider the taxes paid to be the current taxes, and any taxes moving forward are the responsibility of the seller, or the buyer, I apologize. I took a look at the purchase agreement that Neighborgood used. It doesn't appear to be the Uniform Purchase Agreement, but the same type of language appears in this agreement as does the Sarpy-Douglas, the Sarpy-Douglas paragraph in the Uniform Agreement. The statement, purchaser shall pay all real estate taxes for subsequent years. So in drafting those documents, the county was not involved in any way. Neither the treasurer nor the assessor has any input or really any kind of concern as to who pays the taxes, as long as they get paid. So when these agreements were drafted, the county was not a party to the agreements. The county did not give any input on what the terms may mean, nor did they provide any advice to anyone involved. In looking at options for Neighborgood to see if there was anything that the county could do, the first thing I looked for was there any ability at all for the board to waive the deadline for application? For these permissive exemptions, there is no permitted waiver that the legislature has granted. I looked at other types of exemptions to see if any other kind of exemption beyond permissive might apply that we could use in order to automatically apply an exemption. Unfortunately, given the type of organization and the facts of this matter, there weren't any other types of exemptions that we could apply. Neighborgood has requested that if the taxes can't be dealt with through a waiver of a deadline or some sort of processing, that the taxes be abated. Unfortunately, in the statutes, there is a specific statute with direct language that says it is not permissible to abate taxes. So that, again, unfortunately, is not an option either in this case. It is possible that there are other civil types of remedies available, but because the county was not a party to any of the transaction, nor did the county have any input into how these things were set up, it's not something that the county would be able to assist with. I can answer any questions.
Okay, a couple things come to mind. So based, and I think when it was presented as well, at closing, it closed on the 30th of December. So
Yes.
they probably were prorated 1 or 2 days of taxes at that point.
My understanding, yes, is that there were, and I think it was $40 or $45. I think Bill would have to clarify on that one. Because of the way that it was, because of the way the purchase agreement was set up, though, it took the current taxes that had been paid during 2024 instead of what had been due. So the taxes that the sellers had already paid,
Okay, so
they ended up paying back.
You're saying it the same way. It's just,
Yes.
Yes, I got it. Okay, so 2 days of taxes. Okay, and that was for tax year 2024.
The taxes that were paid in 2024 was technically tax year 2023.
Okay, so 2024, are those ones in question then?
Yes,
Okay, which would be paid
this year.
this year? Okay, so with that, you had made a comment on what you were looking at, that it looks like at state statute level, they want an organization or a property to be at least tax exempt for a half year when it changes hands. That was something I thought I heard you say.
Yeah, it appears that way based on the deadlines for permissive exemptions.
Okay, so then, and then the other thing is the question that came up was Douglas and Sarpy County treat things differently with the uniform agreement. and they treat differently as they only look at the taxes due in the current year, which are for the prior year.
Yeah,
And they don't go beyond. And you said the other 91 counties will look at an estimation of taxes for the year. Okay.
that's in the uniform. Theoretically,
Right.
you could come up with an agreement on your own in any of these
We all
counties.
do everything the same as far as taxes in arrears, but the way we handle the tax situation is different.
Yes,
Okay. And I don't think there's really an issue with the 2023 taxes because they were paid.
correct.
It's the 2024 and then not being able to get an exemption right away the way things are set up.
Correct. And I think the uniform agreement is something that was drafted by the Board of Realtors.
Right.
And so my understanding is this dates all the way back to the 70s, and I don't have a lot of information as to what generated that.
So the only question I will ask
Okay.
is now is if someone's in this situation in the future and it's in Douglas or Sarpy County, they would just need to request that portion, they would need to negotiate that in for the future year taxes
Yes.
in the agreement.
Yeah.
But again, you're limited to when it's at the end of the year like this, it's just SOL.
As far from the county perspective, yes, unfortunately.
Yes. Okay. But the state is saying they would like to see a property at least 6 months prior to that exemption. Now,
That's how I
it's a little different if it was exempt to exempt.
Correct.
Okay. But this was not. This was private to exempt. Okay.
Yes.
Yes, I love how everything's so complicated.
Yeah.
So the major problem here is that the taxes that are at issue were for a period of time that a non-exempt entity owned the property.
Yes.
And in the pantry's purchase agreement, they agreed to pay those taxes, right?
It appears so, yes.
And, just by way of explanation, I don't know why the uniform agreement says what it says. I actually am of the opinion that it shouldn't be in the uniform agreement that way because you can contract for whatever you want in your purchase agreement. I think it's confusing to people that the Board of Realtors agreement says something and you don't have to agree to pay taxes just because you're in Douglas and Sarpy County. And I've seen lots of purchase agreements where they didn't do that. They agreed to do it on some different basis. So I'm not sure that that's the way it should be in there. And I probably will raise some issues in the Bar Association on that topic. But the problem is we don't have authority to fix it or provide a manner of relief. And I would say not for lack of trying. I mean, we support the pantry's mission wholeheartedly. We gave $400,000 of ARPA money to the pantry. We think they're a great cause. I wish we could have found some means that we were able to assist here. Looking at our options, there just aren't any. I know that you've dug deep on this, Annie. I appreciate your help in looking to see if we had some means of providing some relief or forgiveness or something. I just don't see that we have anything based on your research and analysis of the issues. I also called several people and tried to reach out and find if there were options here, because we certainly would like to support the pantry and, not having the money go to taxes. We just don't have a legal means to do so. So it's disappointing.
I think there's two things really, and I agree with Commissioner Burmeister that we probably need to look at the Board of Realtors for the county and say, hey, maybe this needs to be changed or taken out. But then at the state level, I think there's also room for making things less complicated. And with this exempt to exempt is okay, but private to exempt is not. I don't, if you're exempt, you're exempt.
Yes.
If you meet everything and you qualify, there shouldn't be any time. We have enough deadlines, and we're really strict on deadlines, but then we don't give any forgivens. We don't forgive when people don't meet a deadline, but then we also have these crazy ways of looking at things. And so I think some language at the state level needs to be looked at. You've kind of found that, and I think we need to pursue that with some of the state senators to maybe correct some of this, because it just seems, well, it's overly complicated and then just flat out wrong.
Okay. Any other
So-
questions? Yes.
Can I just, if I don't have the authority to change it, why are you bringing it before me in the first place?
Well, at the open public comment, you had asked if this could be readdressed and discussed. So that's why it's on the agenda.
Well, I mean, you're a lawyer, you went to law school, you've illuminated the law, and, but you don't have the authority to make the decision, we do.
Yes.
I think it's stupid law, and if I don't vote in accordance with that belief, nothing's ever going to change, because I don't know how many times we've gone over this. It's ridiculous. I sit on the Board of Equalization as an elected official, and it's my right to disagree with the statute. When the statute is clearly unfavorable and almost punitive to the taxpayer in this case. So I really do appreciate what you're doing there, but I get to make the decision. So I'll respectfully probably not follow your advice. And you know what? If the state doesn't like it, they can come back to me. That's fine. I really don't care. It's just not right. So, I mean, I think all of us can recognize right from wrong. It's not a hard decision for me. So appreciate your legal counsel, though.
Yeah, so we have no resolution to grant a permissive request. I mean, what are we voting on?
This is just information.
This was informational based on a request to put it on for discussion.
All right, thank you.
Looks like the pantry would like to be recognized.
Andrea, I appreciate the time and efforts you've put into this. Same with you, Commissioner Burmeister. And to reflect Commissioner Burmeister's comments, certainly we wish you guys nothing but the best, and we fully support what you're doing. It's a great asset to the community. I'm sorry that there isn't anything else that we can do. But if you'd like to address the board, please do come forward. And for the record, if you'd please just state your name and address.
Andrea Powers, President of the Board of Directors for Neighborhood, 12619 South 76th Avenue, Papillion. First off, again, thank you all for your time in looking at this matter. We really do appreciate it. Thank you for asking those questions, because again, we did not have a chance to prepare for what was going to be said, and so this is all off the cuff, so apologize. You had a lot of the same questions that as she was talking that I did. I think the big things to take away here is there was not a deadline we could comply with to be tax exempt for that year. Secondly, as was stated, our purchase agreement was similar in fashion to every other Douglas and Sarpy County one. Had we done something different and said, hey, yeah, no, we want to be different, you pay the taxes, we wouldn't have had the building. We would not be serving the people of Sarpy County in a more dignified way the way we are doing now. Something for you, Mr. Kelly, ammunition for, that this is a messed up kind of process is by doing things this way and making the new person, even if they aren't a nonprofit, pay those taxes for the year prior, we are benefiting people who are selling and likely moving out of Sarpy County. And they're basically not paying their last years of taxes. Whereas, so now we're punishing the person coming into Sarpy County who's buying property, because now they get to pay the 2024 taxes. So just a thought that doesn't make sense that we're, thanking the people that are potentially moving out, but we're sticking it to the people who are coming in. Couple things that were disappointing, I will say, are our treasurer, Bill, did his due diligence and reached out to the assessor ahead of time and said, We don't want to do anything that's going to cause us to have to pay taxes. We realize now that there was no way that was possible, but he didn't even give us that heads up. It was fill out the 451, we thought everything was good to go. Secondly, the first we even heard that we actually owed property taxes was May. And it was a statement that said, your property taxes are past due. So the deed is registered. I would have thought, at least at that point in January, that we would have gotten a property tax bill and we could have been dealing with this way back when. But now we're already accruing late fees by the time we found out that this was happening. So I guess I would ask, I don't know what you have the authority to do, but I guess what's really I'm having a hard time with is the fact that we are now paying our property taxes to Sarpy County so that we can serve the residents of Sarpy County, and we're paying taxes that were from last year when we did not own the building and didn't occupy the building. That just seems so ridiculous to me. I can't even wrap my head around it. So, and yet it appears as though there really wasn't anything we could do to prevent that. I guess I would offer up, is it an easier way? I know you've supported the pantry in the past, and that is fantastic. Thank you so much, all of you who would have voted for that. Of note, those were federal funds. Thank you for allocating them to us. But so technically, Sarpy County, from their coffers, has not actually supported the pantry financially. Is there a pot of money that perhaps you can help support a program that might have to be cut short due to us paying $13,000 in property taxes? Would just be a thought. Welcome any other further conversation, whether that's today or tomorrow.
I will give you, here's what I'm thinking. You can take it for what it's worth. The private party or the people that you bought the building from, maybe you would just fill them in. Mm-hmm. And also the Board of Realtors, and maybe ask, how much taxes are we looking at? What are you going to be out with the taxes and the accrual of interest and late fees?
Yep, it's like $13,000.
$13,000.
Mm-hmm.
I would go to both of those organizations and see just the question you asked this board. I would go back to them and say, you have no obligation to do this, but.
That is a fantastic, we can do that. I know the seller was selling for reasons that he would not be in a position to help in that way. But we can certainly do that as part of the due diligence.
Right. And I would also say, because this comes up, and I agree with Commissioner Kelly as well, it's very frustrating to sit on this board when we do not have the power to override. Even if we vote, the state comes back, it's overridden. It's really frustrating. And laws are so complicated and they're so outdated.
Right.
And so I will say to you, your state senators chirp in their ears about this stuff and let them know. And let them know that they're all out there trying to introduce so many bills every year. Instead of trying to do that, why don't they start cleaning up and making it right, the things that are wrong?
Absolutely.
So you're the voice. I wish we had more voice to do. We voice it, but we don't have the power. So
right. And again, I know you're all reasonable people. I think you probably all agree with us that that's just ridiculous. So maybe there's a different way around it other than you putting your heads out and voting.
Go to the Board of Realtors. They surely should be able to give you a nice donation.
Well, the other thing I would point out is you might want to have somebody look at your actual purchase agreement. It doesn't match the Board of Realtors agreement. And so I'm not really sure how I think you might want to have analyzed whether or not the seller owed some of those taxes based on the language of the purchase agreement. The language is different. It doesn't have the same language as the uniform one that the Board of Realtors uses.
Right. But I mean, I know we did talk about how they can vary. And so I think there's going to be some natural variation just based on who drafts it. So
right.
We can look into that, but I don't know that I don't see that being an avenue, but we will certainly look into it.
Yeah.
But if that's the standard verbiage for Sarpy and Douglas, that's
It's
why
not,
we use
though.
standard.
Your agreement doesn't have the standard language. It's missing provisions out of there. That's what I'm saying, is the agreement that you actually had doesn't match the uniform one.
Oh.
So you might have somebody look at that.
I thought that's what she had said, is it matched, or it was similar.
Yeah, it's
Okay.
similar, but it's.
Can you show me what's different afterwards?
Yeah,
Okay.
The uniform agreement that Douglas and Sarpy used for the Board of Realtors says that the year in which closing takes place, the taxes that are due will be treated as current taxes. The taxes for this year, 2025, are 2024 taxes. That's the wording. I was in that business for a long time. Prior to it being written into the contract, that had to be written into the contract. So,
Yeah, and it's
Yeah, I
actually
guess-
it's not Douglas and Sarpy that did that. It's the Board of Realtors.
Yeah,
Just
nothing
put
to
that
do
in
with
their
us.
form agreement. None of us could figure out why they put it in there, because
Oh, yeah, I
it
can
can
tell you
say
why.
whatever you want it to say. It was probably done for realtors who, they're just checking boxes, not doing the legal analysis of what that provision means. So it was done for that purpose, so that then when you change it, you can change it. It's just that often realtors don't. They just pick whichever one they want based on what the Board of Realtors did. But it's not the county that put that together. It's the Board of Realtors.
We do
that
understand
did
it. Yep.
Yeah. And I don't know why. It's,
or whoever did your
interesting.
paperwork. I mean, if it was an attorney that did it, that should have been
Yeah.
explained.
Well, in your particular case, whoever drafted the contract is who put there. It's confusing because the Board of Realtors has a uniform agreement that a lot of people use, but not everybody. A lot of the ones on, commercial purchases wouldn't use that one, but yeah. So it is confusing, and it's frustrating that we don't have authority to do something in this scenario where it would make sense for us to have authority. But the legislature limits our authority, and we buck up against that all the time, quite honestly, which is why we were down the rabbit hole of trying to figure out, do we have any possible legal means to help you? And, we were hopeful that we could find something, and we just weren't able to.
Well, thank you for your time.
Thank you.
Hey, Annie, I have a question. Just it's just kind of hopefully get me back up to speed here.
Okay.
So we're having a discussion today. Has the actual exemption request been voted on or made?
It was, the application that came in, they had crossed out 2025 on the application and put in 2024, but when it was presented to you, it was presented as a 2025 application exemption pursuant to NDOR and assessor policy. But that was back a couple months ago, and it was approved for 2025 exemption. So they are exempt for this year and won't have anything due next year.
But do they have a mechanism to come back and appeal the 2024? Is there a way the county board of equalization can weigh in on that request like that?
If we go back and process the first application as a 2024 application, that would mean there was no application for 2025, which would end up removing the exemption for 2025. A new application for 2024 could be submitted at this point. The board could process that. It's well beyond the deadlines for application, but the board could take an action on it that could then be appealed to Turk. I don't know. It's my opinion, Turk wouldn't have any action.
It could be appealed to Turk, but
It could be at that point.
it doesn't have to be appealed to Turk, correct?
No,
Okay.
but it would give a final action by the board if that's what you're looking for.
Well, that's all I ever asked for in this job, but it just drives me crazy that whatever I want to do doesn't matter because somebody at the state thinks they're smarter than we are. And they're not all the time. Sometimes. Well, at least for Commissioner Mixon, but not me. No, I'm just kidding. But you see what I'm saying here?
I do.
We sit here in judgment, so to speak, as a board of equalization on valuation or protests or a whole number of things. And no matter what we do, It's disregarded, or it's appealed down at Turk, which costs the county taxpayers more money. And so you sit up here and you have to wonder at some point, well, why are we even bothering to do this? If we have no authority to correct an obvious wrong, what's the point? Now, can you give me a legal opinion on that? No, I'm just kidding. No, it's not your fault.
I
mean, you're just, but see, my whole philosophy is that lawyers advise and leaders decide. But if I can't decide, then what's the point? So if there's a way we can bring this up so that the board can weigh in, and maybe it'll be a 1-4 vote, I don't know, maybe it won't be. I'd sure like to put my marker down on it.
Okay.
So, thank you.
Yeah.
Good afternoon, Board. I'm Joe Chase, 902 Mackenzie Drive. I've been a volunteer with the pantry for quite a while here to help them with their facility issues. So I just want to clarify with her comment and so could the pantry put in a new application for 2024 and request a waiver on the 2024 deadline? And then that would go through the process? Is that what I heard?
That's what I asked, but I'm not a lawyer, so.
Would that be
You could do that. My recommendation at that point to the board would be that they don't have the authority to grant the waiver, but you could do that in order to have a final determination that you could bring to further steps if you chose to do so.
And to prove they don't have authority, I'm a part of a tax exempt organization that failed to file a timely application. The board, I sat out of the meeting, the board went ahead and voted that it be granted anyway. It went to the state, they turned it around and said, no, it was not timely filed, therefore, so in keeping with previous state action, I would hope they wouldn't do that.
But that would be an avenue. But that would be an avenue that we should take right now, based on the conversations that we've had here.
Yeah, but I'm just telling you, I know I've been a part of it before, and the state turned around and kicked it right back to us and said, no, that was an improper decision to do that. Because it passed the filing deadline.
But that would give Mr. Kelly and
Well, you
any
can
other
do it.
members
Yeah, I'm just
the
saying.
opportunity to make a decision and move forward.
You can do it and we can vote, but I mean, you could say it's worth a shot. To Jim's point, though, I don't think there's a great deal of hope in that process, but.
I think the last point I would make to it is we could do that, and if we would vote in your favor and it would go to Turk, I would say at that point, I would not support any more taxpayer money to do anything to appeal or do anything at Turk, because it's probably a way, I don't want to waste any more taxpayer money. So that's where I would be at, because like Commissioner Warren said, we've gone down this road and we've said, okay, and then the state gets it, and then they look at everything, they kick it back, and then it comes back. Then our legal comes to us, well, what do you want us to do? And so I'm just going on the record that I wouldn't spend any more taxpayer money.
But at that point, we'd be able to appeal to the state.
You might be able
Yes.
to on your own.
The pantry could appeal to the state independently from the county board and see if they can get a different solution.
Right. But
And I would be very disappointed as a member of a nonprofit organization that the state kicked it out for the same reason you're asking for the appeal.
Yep.
So I would assume that the state's going to be consistent in their answers. It's just one of the many things. We give liquor license, and then they go to the state, and they can either say yes or no. I mean, this is one of those things we should not be involved in, my opinion. One of the many things dysfunctional about county government.
I appreciate it. Thank you.
Yep.
Thank you. All right, any further discussion on item 6.1? Hearing none, we'll move to 6.2 as a protest hearing, rejection of homestead exemption Form 458R for Lot 35, Southern Pines, replat 1, parcel 0115947008. Kyle Perez. Any questions for Dan Pittman on this one as far as the,
Motion to approve. Oh, it's a hearing, huh?
No, it's
Is
not
this
a
the one that
Oh,
we
it is a
have?
hearing. Yeah.
This is a hearing.
Kayla, is this the one that we have authority to extend the deadline on?
Yes, you can extend the deadline until July 20th on this matter.
excellent. This is a public hearing. Is there anybody from the public that wishes to speak to this item? Hearing none, we'll close the public hearing and
So,
entertain a motion.
so Don, your motion is to reject the homestead exemption, or is that what you want to do?
No,
Okay.
can we extend it?
Yeah. I'd say.
I'll second the motion to extend the deadline.
Thank you.
All right, motion to extend by Kelly, second by Burmeister. Any further discussion from the board? Hearing none, please vote.
I vote for that.
Okay.
Four.
I'll second both for. Okay.
I would,
All ayes?
yeah, I'd like to suggest if our system's not working, let's just do
Okay.
a vote of record instead of the system.
Don moved and I
Donna
seconded.
and Burmeister?
Yeah.
Okay.
I mean, I'm back on, but it's frozen.
Okay, that's fine. So,
there we
ayes
go.
5, nays none, motion carried. Correct?
Yeah.
Okay,
Yep.
got it.
All right, up next is 6.3, notice of valuation change, put in the Greenbelt 1, Dan Pittman, County Assessor. If we have any questions from the board, comments?
Motion to approve.
Second.
Motion by Warren, second by Kelly. Any further discussion?
No, I'm
right.
sorry, I'm voting yes.
Those in favor, go ahead and just say aye. Aye.
Aye.
Aye.
Ayes 5, nays none, motion carried.
All right, there's no need for executive session this afternoon in the BOE, so with that, all agenda items having been addressed as published, the Board of Equalization is adjourned. All right, the time is now 3:37. I'm calling to order the Board of Commissioners. Today we have with us Commissioners Kelly Burmeister, Warren Mixon, and Klug, as well as Bonnie Moore, our County Administrator, Kendra Kaler from the Clerk and Register of Deeds Office, Jeff Meixel and Jason Carter from the Treasurer's Office, and Dan Pittman, County Assessor. With that, I will open up to public comments. Is there anybody in the public that wishes to address the board before we move on to the remainder of the agenda? Seeing none, we'll move to item 4, Commissioners, Administrators' comments and announcements. Commissioner Kelly.
Nothing, thanks.
None, thanks.
No.
No comment, thank you.
All right, moving on to item 5 is the Consent Commissioners' Agenda.
Motion to approve.
Second.
Motion by Warren, second by Kelly. Any discussion? Please vote.
Hey, there we go.
Angie, you and I?
I'm an aye.
Okay, ayes 5, nays none, motion carried.
All right, moving on to the regular Commissioners' Agenda. 6.1 is Resolution 2025-174, agreement between Sarpy County Department of Corrections and At Ease USA for mental health support services, therapeutic and peer support. 2, for veterans in Sarpy County, Veterans Court, and veterans held under the jurisdiction of the county in the amount of $20,000. Joe Martin, Corrections Director. Welcome, Joe.
Good afternoon, Commissioners. It's been about a year, and At Ease has been coming into the jail, and we've had a wonderful experience with them, and we're hoping to continue the partnership. And I'd like to bring Gail Williams up from At Ease to say a few words.
Welcome.
Good afternoon. I'm short, just going to move that down a little bit. I am Gail Williams. I'm the clinical director for At Ease USA. And if you're not familiar with us, we are a nonprofit here locally supporting not only active duty military members, veterans, but also their family members. And so we provide support for the whole family. I am a military brat, spouse, a mother, so this is really one of our biggest causes. Your support has really helped us and allowed us to serve the Veteran Treatment Court, which I'll speak to first. We spent about 500 hours in Veteran Treatment Court. I am the clinical liaison, so every morning on Wednesday at 7:30 a.m., we show up and we help support the treatment decisions that are being made for these veterans who suffer with post-traumatic stress, traumatic brain injury, and then suicidal ideations or past attempts. And so we know that most veterans go untreated, which is why they end up in legal troubles. And so your support of that $20,000 has helped us with those veterans and Veteran Treatment Court. We recently had our first graduation. It was so moving. Judge Nathan Cox is amazing and really does good work with considering all the factors that our veterans face. And so as it comes to the jail, we had to find the right people to go in there. So we provide peer support services as well as therapy, which is our most expensive service to the incarcerated veterans. And so we've spent about 500 hours between the two services at the jail over the last 12 months. So again, these veterans are suffering because they're going untreated. And so we finally are now seeing some improvements in progress in their mental wellness because of the programs that we're providing. In addition to peer support and therapy, we do wellness programming as well. So the veterans who are in Veteran Treatment Court participate in financial literacy classes that we partner with certain organizations to teach them about financial wellness and legacy. A lot of these veterans, the enlisted ones anyway, they come in when they're kids. They go in 17, 18, 19 years old, and then they get out and they don't know what to do. So we provide that service as well to help them to be more productive citizens in their own families, number one, and to the community as well. I recently had the opportunity to watch a film. It's a new release coming out this fall from a production company in Kansas City. It's called Sheepdog. And it tells the story of a veteran who had a flashback in the community, and because of his actions, he was arrested and ordered to Veteran Treatment Court. And it just shows this beautiful story. Well, not all of it's beautiful, but how his service contributed to him losing his family. His brother served with him, lost his brother. But then the redemption of how he was ordered to go to Veteran Treatment Court. And it walked through all of the processes of the peer support, the therapy, the group therapy, and how this veteran was able to begin the healing process. And I've been lucky and privy to see this happen firsthand with our veterans. In that movie premiere, there were about 20 veterans in there, not a dry eye. And they said, this was one of the first times my story was told where it really felt like they understood me. And so when it comes here to Omaha in the fall, I would love to invite anyone who would come out and see it. I think anyone who's involved in veteran affairs should see it so they have a better understanding. And so again, thank you for your support. Should you have any questions, I'll be happy to answer.
Thank you for being here and everything that you're doing for the veteran community. It means a lot. So thank you very much.
Thank you.
Is all those things you're doing, is $20,000 enough?
No, we spent $50,000 so far this year, from June to June. So it is not enough. My executive director is trying to pound doors and find more funding. And so we have talked about, do we have to cut back? And we don't want to have to do that. So we don't want to turn anyone away.
So is Addie's in the Combined Federal Campaign Fund as a charitable organization? CFC?
I'm not sure. That would be my executive director. It's above my pay grade. I'm not sure. I don't do the fundraising, but I'll ask.
Okay, thank you.
What was the name of it again?
CFC.
CFC.
Combined Federal Campaign.
Okay.
They do it once a year. It's local and national charities.
Okay. Thank you for that. Okay. Have a good afternoon.
Thank you.
Thanks for your work.
Motion to approve.
Second.
Motion by Burmeister, second by Kelly. Any further discussion from the board? Please vote.
Ayes 5, nays none, motion carried.
Up next is Resolution 2025-172, award the low bid to Continental Fire Sprinkler Company for the design and installation of a clean agent fire suppression system for the Facilities Management Department in the amount of $126,440. Beth Garber, Assistant County Administrator.
Thank you. On June 20th, the Purchasing Department did open one bid for the design and installation of the Clean Agent Fire Suppression System. The bidder was Continental Fire, and the bid amount was $126,440. This is within the budgeted amount in capital projects. The project adds a Clean Agent Fire Suppression System to 3 information technology rooms in the Correctional Center that are currently protected by a wet sprinkler system. The work is expected to begin this month and be completed by September of 2025.
Thank you, Beth. Any questions?
So is this a foam or?
I believe it's, PJ, do you know exactly what they're using? If it's a chemical where it sucks the oxygen out?
Oh, so it wouldn't affect the
Right,
equipment?
it shouldn't.
Okay, that's pretty awesome.
Motion approved.
Was this available when we built the jail? I mean, instead of,
So there were clean agent fire suppression systems available when we did build the jail. We, at that time, chose not to do that and to defer this to a later date.
Second.
okay.
Motion by Warren, second by Burmeister. Any further discussion? Please vote.
Ayes 5, nays none, motion carried.
All right, last up on the regular agenda is Resolution 2025-183, Guaranteed Maximum Price Amendment Number 2 to the Contract for Construction Management at Risk for the Sarpy County Jail and West Annex Demolition with Beckenhauer Construction, Inc. in the amount of $1,738,418. Beth Garber, Assistant County Administrator.
Commissioners, thank you. On February 4th, the county board approved the construction manager at risk contract for the jail demo and West Annex demo to Beckenhauer Construction. You did approve GMP 1 on April 1st for $935,791. GMP 1 included the demo of the jail, the demo of the West Annex, and grading of the West Annex site. This is phase 2 of the project. This is the exciting phase, in my opinion, for $1,738,418. It includes parking for the jail site, better access for semis coming in through the Pinnacle Bank along that west side of the parking lot. It also includes sidewalks and curbs for safety for pedestrians walking through our parking lot. In the West Annex site, it will include includes a fence and a sidewalk along the West Annex where the West Annex frontage was. The work for this will begin on July 28th, and construction will be completed at the end of the year.
So this is the full package?
This is the full package. It will have 217 parking spots when it's completed.
Concrete?
This is on budget or?
This is in budget. So we had, the total project is $2.6 million. We had $3 million in the budget for this.
Okay.
Parking lot, concrete or asphalt?
Concrete.
Okay.
I want a brick.
Got a whole bunch of bricks.
Yeah, we'll get those in there for you, Commissioner.
Yeah, I would like that.
I have a brick I'll give to you.
Motion approved.
Second.
Motion by Warren, second by Mixon. Any further discussion? Please vote.
Ayes 5, nays none, motion's carried.
All right, next we have item 7.1, executive session for litigation.
For the protection of the public interest, I move we go into executive session to discuss litigation.
Second.
Motion by Kelly, second by Mixon. Please vote.
So this would be next week.
Ayes 5, nays none, motion carried.
It is now 3:48 PM. We'll go to executive session where our discussion will be restricted to litigation.
That's what.
Okay.